the ability to modify those pairings.
Modify is different than you coming before me and saying that I have no constitutional right to proceed today. You do not have a petition to modify, and therefore I cannot modify a court order under Rule 106 once that order has been entered. I cannot modify it on a motion hearing.
What I'm suggesting is that even states recognize that there's nothing written in stone when it comes to parenting, and that having agreed to a particular parenting schedule at one time doesn't mean that that's written in stone forever. And as a fit parent who has a fundamental right regarding my parental duties in terms of their care, custody, and management, I get to decide what's in the best interest of my children.
Not in a vacuum without their mother.
That's correct. And so we both have that same right, and I agree.
And if you disagree, the courts do not impose upon your constitutional rights. The courts determine, based upon two parents disagreeing, what is in the best interest of your children.
Well,
you are entitled to submit evidence, but all of that, sir, is a modification. And we cannot modify your decree here today.
Well, what I'm suggesting is that the modification procedure is also an unconstitutional burden on my fundamental rights, that I'm able to assert that fundamental right at any time, and that's a fundamental right for equal parenting, and determine the level of support, financial support for my children, and that the only thing the court can do is say, wow, okay, we got two parents, they both have fundamental rights, thus heightened and strict scrutiny apply, that the court, in order to, for example, issue an order of child support, has to say, okay, what's the compelling interest? What are the particular findings of fact and conclusions of law that support that particular order? And is it that the least restrictive or narrowly tailored for that? And what the Supreme Court has said is that in the case of care for a child, the state has minimal interest in the care of a child. So there is no compelling interest so long as there's a fit parent.
I'm not going to have this argument with you, sir.
Okay.
The Constitution also tells me that I am required by law to give full faith and credit to the orders of other states. And until that order is challenged by legal means such as a modification, a petition to modify, you did not appeal this order and you agreed to this order. Therefore, you cannot come in on a motion hearing when I am required to give full force and credit to the New Mexico decree.
And I agree that that's the rule. There should be full faith and credit to Mexico, but the agreement itself does not alter my fundamental rights.
You're wrong.
As a fit parent.
You're wrong. And you can file a petition to modify. You can challenge the order as prevented by law, but I am a commissioner and I cannot, as a matter of law, modify a decree of divorce on a motion hearing. You have whatever rights you have to object to my ruling and see a judge. But for today, I am prohibited by law from doing anything but applying the law to the decree as it is written. End of discussion.
I mean, argue my motion?
Yes.
Is there something else? Thank you.
I've read your motion that Mr. Hahn was employed during the marriage until the petition for divorce was filed, that he made $131,272 in 2012, that in 2011 he made $127,140, and that in 2010 he made $127,099. And that her income as a teacher is $2,975. Is there anything else that I need to know?
No, Your Honor, except for I would like to point out in terms of the timing, that the decree does indicate, that their original decree does indicate an effective, their petitioner tries to indicate that it doesn't clearly say that child support shall start, but that sentence clearly says that child support should then be calculated under the New Mexico Child Support Guidelines.
And you submitted to me, though, a Utah child support guidelines rather than a New Mexico.
I did, Your Honor, and I think that with child support, since the Office of Recovery Services was never involved in any state, I believe that jurisdiction-wise, that Utah can take jurisdiction over the child support issues, and it would be appropriate to submit it. Now, my client did also, our request for child support is under two grounds. First of all, enforcement of the original decree, and secondly, she did file a petition to modify back in January, just requesting that child support be entered in case they're under the Utah guidelines, just in case there was any problems with it or the court found at some later point they couldn't do it with New Mexico guidelines. She doesn't have any objection to it being either New Mexico or Utah. I think I ran the numbers and it was actually higher under the New Mexico guidelines, so we don't have an objection as to which state's guidelines should be taken into consideration. Either would be fine, but we are requesting that his income be imputed. In his response, he did agree that income should be imputed to himself. He tried to argue that she should also have income imputed, which I would note is inappropriate in consideration of the fact that she has actual employment. And if he had actual employment, then we could, use his income. And then I understand that for imputation, if he had actual employment and we were trying to impute it higher, that may be an issue for a judge. But as he has no employment, his income has to be, indicated as something. So we would request an average of the 3 years.
Thank you very much. Mr. Utah law provides for imputation of income if a parent is voluntarily underemployed. You are not currently employed, is that correct?
That's correct.
What have you done to get a job since the decree was entered?
I filed for dozens of jobs. I've had one interview.
Do you have those applications here today?
No, ma'am.
What types of jobs did you apply for?
They're related to all sorts of financial services employment, which was my prior employment, financial representative, human resources positions, compliance positions, most recently as an estate administrator.
Sir, my problem is that I don't have the documents, and I would need them to determine whether or not your efforts at finding a job were reasonable.
Okay.
And in a vacuum, I have to find that they are not. Therefore, I will grant the motion to average 2010, 11, and 12 to use Ms. Hahn's current income, and as Ms. Hansen-Pellicastri said, sir, if you had an income, we would use that. Even if it was minimum wage, if we thought minimum wage was reasonable. But I don't have proof as to what you've looked for and why you were denied. Therefore, absent that proof temporarily, and I'm not going to go retroactive, Ms. because of that proof issue, but I will begin December 1st, and I will order that the New Mexico guidelines apply until and unless the order is modified on your client's petition to modify.
Your Honor, that issue of child support arrears is reserved for future determination.
Yes. Because it's all going to be tied into what he applied for and what happened when.
Okay.
All right, would you please prepare the order on both motions?
Your Honor, in regard to the request for attorney's fees, is that simply reserved?
I'll reserve it.
Thank you, Your Honor.
Yeah.
Thank you very much. She's going to prepare an order and send it to you for your review. If you have questions about your rights on objecting to my recommendation, I know you do your own research, but you can also go downstairs. We'll give you the phone number of the Self-Help Center, and they can tell you how to proceed.
Okay.
All right?
May I address any of the issues here, or no?
No, we're
in terms
done.
of- Okay.
So if you'll come pick up this card, please, sir. Thank you very much. Mr. Johnson, camera's off.